Good afternoon. My name is Dennis Herrera, and I'm the City Attorney of the City and County of San Francisco, but for our purposes, a little bit more important, also a member of the ACS Board of Directors who has been tasked with getting this distinguished panel started for what I know is going to be a great presentation this afternoon. Steve Bright, who I'm going to introduce in a moment, wanted to make me the heavy, so shut off your cell phones, put them on silent so he can get things going. But we're really excited about this panel, especially in light of the comments that Tony West just had to say, especially reminding us that 50 years ago, the United States Supreme Court decided Gideon versus Wainwright, one of the most renowned and celebrated cases in our constitutional history. And our next plenary session is focused on that. It's focused on reclaiming Gideon. And here to introduce the panelists is a longtime ACS friend, Stephen Bright, who actually keynoted the first ever ACS student convention at Stanford back in March, which from everything that we've heard was a resounding success. So thank you so much for that, Stephen. Steve is president and senior counsel at the Southern Center for Human Rights in Atlanta and teaches at the law schools at Yale and the University of Georgia, although I don't think he does that on the same day, though. Impressive as he is, subjects of his litigation, teaching, and writing include legal representation for poor people accused of crimes, capital punishment, human rights violations in prisons and jails, and judicial independence. He has argued capital cases before juries and before the U.S. Supreme Court. The Fulton Daily Law Report named Steve Newsmaker of the Year in 2003 for his contributions to bringing about creation of a public defender system in Georgia, and he received the ABA's Thurgood Marshall Award in 1998. I cannot imagine anyone more qualified to lead this afternoon's discussion. Please welcome Stephen Bright.
Thank you very much, Randy. Thank you. Thank you very much. I appreciate the introduction. I think part of why I was asked to speak was that some thought my views might be slightly different than the Attorney General of the Department of Justice. But I want to thank ACS for putting indigent defense on the agenda. It's not always there. I know many of you labored in other areas or do labor in other areas, and so part of what we're going to try to do is describe a little bit of what the situation's like, although Tony West did a good job of explaining much of that, but most importantly, talk about how little is being done, but what needs to be done to move us forward on this. The criminal justice system sends 2.3 million people to prison and jails in this country, and we ought to be somewhat concerned about how they get there. The criminal justice system is a part of our society that's been least affected by the civil rights movement. In the areas where I practice, we see change. John Lewis is our congressman now, where I live. We see changes in the legislatures, we see the city councils, but when you go to court, it's like you're back in the 1940s. The judge is white, the lawyers are white. The only people of color, it looks like a slave ship is docked outside the courthouse, and all these African-American men are there, brought in handcuffs. And I want to talk just a little bit about the kind of representation they receive. We have a panel here that's going to discuss this, a distinguished panel, two state public defenders who will tell us sort of what's going on in the ground in New Orleans and in El Paso, a federal defender who will pick up where Tony West left off and talk about sequestration and the threat to the right to counsel, the Chief Judge, Jonathan Lippman, who's taken the real leadership, Chief Judge of the New York Court of Appeals, on judicial leadership in this area, which is so desperately needed. And Scott Burns, who's with the National Association of Attorneys Generals. Let me just say a couple or three things, two things really, that I want to say and then introduce the panel. What we learned on the 50th anniversary of Gideon and what I thought was remarkable were two things. One, everyone agreed how terrible the situation was. Nobody said, let's have a big celebration. Everybody said, like the Attorney General did and like Tony West did, this is a crisis. This is terrible. We haven't lived up to it. But the other part of it's important is how little is being done about it. even though everyone agrees. You know, Tony West mentioned resources. There are not enough resources for indigent defense. There's always enough resources for indigent prosecution, but there's never enough money for indigent defense. One suggestion I have for the department to deal with getting more money for these areas and sequestration. Since September, 4 death penalty trials have been tried to jury in Puerto Rico, a commonwealth whose constitution prohibits the death penalty. And yet the United States of America goes down and holds death penalty trials in Puerto Rico in the federal courts, never get it. The juries have never imposed it, but we had 4 trials from September until now. Millions of dollars in trying capital cases in Puerto Rico, of all places. And that might be a place where we could move a little money around to maybe put it in a better place. I want to just add to his comments. He talked about crushing caseloads. There's no doubt about that. No investigator. There's no doubt about that. In many parts of the country, there is no adversary system. But I just want to add a couple of things about how much worse it is. Gideon said there was a right to a lawyer. Several cases after that said juveniles, anybody facing a loss of liberty was entitled to a lawyer. And yet we have judges all over this country, north and south, conducting hearings where there are no lawyers at all. They're having hearings, or juvenile court is having hearings and locking kids up and sending them off without any lawyers. Misdemeanor courts in Kentucky, only 30% of people charged with misdemeanors in Kentucky have a lawyer at all. It's not quality of lawyers, caseloads, these are no lawyers. And the same thing is true in a lot of other courts where we see. And then the kind of representation people receive. I was in Georgia just last week, 79 cases on a calendar. None of these people had talked to lawyers before. The judge told them when they came in, you can either talk to the district attorney or you can talk to the public defender, as if there was no difference between those two. And many of them spoke to the public defender. They were screened for eligibility. If they weren't eligible, they were told, we can't represent you, you're not eligible, talk to the district attorney. And many did and pled guilty that day. But almost 90% of the docket was handled by public defenders. And they met the clients, they talked to these people they'd never met before, they didn't know anything about their cases, didn't know anything about them. And they met with them, the judge took a long recess from about 9:15 until 1 o'clock. And then they came back and took guilty pleas from these people in groups of 5, 7, 10 people, all pleading guilty at one time. They had about 5 to 10 minutes worth of legal representation. I don't think that's legal representation. There are no professional skills that a lawyer brings to that. If you don't know anything about the client, don't know anything about the case, if all you can do is say, here's what the plea offer is, and it expires in 2 days if you don't take it. You can go out today free on probation. Because what they don't tell you is you're going to go out with fines you can never pay, so you're going to be revoked shortly. That's not legal representation. We can teach high school kids to do that. And it's not just, as I said, in the South. We have many states that don't have public defender offices at all. Alabama, Texas, prominent among them. We have many states that still leave it up to counties, New York and California being prominent among them. Many California counties award out representation of poor people to the lowest bidder. One lawyer there said that he was able to handle a high caseload because he pled 70% of his clients at the very first appearance hearing after a 30-second conversation. In Michigan and in Minnesota, the courts have been called the courts of McJustice. In California, these contractors are known as the Walmart of representation. I don't think it speaks well of our criminal courts to be compared to Walmart and fast food restaurants. I guess you could say for McJustice, the slogan could be over 250 billion years served. But I want to just talk about what's being done about it real quickly. The Attorney General said it was a state of crisis back in March when we talked about Gideon. I appreciate all that Attorney General Holder said about indigent defense. It's the first time since Robert Kennedy the Attorney General has talked about indigent defense. I wish you would talk to the Association of Governors. I wish you would talk to other people than defense lawyers about this, because it really would be much more important. This is out of sight and out of mind for most people. And the Attorney General has lots of forum. But next week there will be a showing of this film here in D.C., and the Attorney General will be there, and he'll talk about how great public defenders are. But when he was making his talk about Gideon, I was sitting there doing the math, and it comes up to about $5 million, the grants and so forth that are involved there. There's some others, and I certainly commend the Access to Justice Project and Deborah Leff, who's here, and Karen Lash, and the tremendous work that they are doing. But if ever there was the dance band on the Titanic, that office is it. And I say that as a compliment. You take the total amount of money, it's about $10 million, which, let's face it, is nothing. Here we say 50 years later, all these terrible things are going on. We don't have any governor say, I'm going to improve indigent defense. We don't have any bar association say all the lawyers are going to chip in $1,000 to improve indigent defense. We don't have anything. And I think that the Justice Department needs to do a lot more than what the Attorney General and what Mr. West has said. Some people now are proposing a commission. We ought to study indigent defense. I just want to say, if there's any subject that's been studied more than indigent defense, I don't know what it is. The ABA, authoritarian organization, authoritative, legal, whatever it is, well-respected, nonpartisan, has issued its 10 principles of indigent defense that tell us what needs to be done. It's not rocket science. Right there, it distills all of the information of these studies over the years. It's time to do something. That's my last point. It's time to put boots on the ground. When President Clinton talked about law enforcement, they somehow came up with 100,000 police officers. When President Obama talks about school teachers and science and mathematics, he needs 100,000. It's amazing to me. You figure these things out, it always comes out a nice round number like 100,000. But I believe we ought to be calling for 100,000 public defenders in this country. We ought to go back to what LEAA was doing in the 1970s out of the Justice Department, which is setting up model programs. I'm so glad to hear that Bob is coming from the Philadelphia Public Defender to deal with juvenile cases. We need to set up programs. You could do what was done in Shelby County, Tennessee, in almost any county in this country. We need more use of training programs like the one featured in that film. John Rappings, Justice funded it at one time, doesn't fund it anymore. That it was a chance for people to graduate from law school, get trained on how to be a good public defender, and then go into offices like Derwyn's and others and actually do a good job representing people. Mental health units and all of those things. But I won't say any more about it except that I hope today we can talk a little bit about what do we do about doing something about these problems and moving from this inertia of talking about it, studying it, to actually doing something. And I'd like to ask Derwyn Bunton, who's the public defender for New Orleans, which may still be the most unhealthy city in the country. I'm not sure, but they told me not to drink the water there. But I want him to talk about, Derwyn has done a heroic job since Katrina in building a new public defender office in New Orleans and trying to actually provide people with the kind of representation that Gideon anticipated. And so, Derwyn, could you tell us what's on the ground?
Sure. Well, first, thanks for having me here. It was an honor to be here with Steve and my colleagues, and to be able to talk about indigent defense, particularly in New Orleans. And I really want to talk about I really want to hit three things that have been bugging me lately, because I get things that bug me a lot as the chief public defender in New Orleans, but it's resources, parity, and then just simple justice. And I'm getting older. How many folks have seen A Few Good Men? It's like, lawyers love lawyer movies. But hate to admit that we love lawyer movies. And A Few Good Men is one of my favorites. One, I love Jack Nicholson, and despite being a bit crazy, Tom Cruise is a very good actor. And the whole idea of looking at a few good men and juxtaposing it against what I deal with every day is something I did recently because I got to see it again for, I don't know, maybe the 30th, 40th time. And it all begins with, this hotshot lawyer and some things have gone bad at this base. And he gets to work. And one of the things he does is puts together a team, right? It's not just one lawyer. It's a team of them. And if you go to state courts and if you're in public defender offices, you are rarely going to see teams. There's going to be a single lawyer who's handling 2, 3, 4 times what the ABA says the standard should be, and they'll be going along to get along. If they're low-end contractors, they may say, "Well, this is easy. It's just a crack case. It's just a heroin case." Despite the fact they're a multiple offender, and if you lose, it's 20 years to life, it's still just a crack case. And those are the sentences we face in Louisiana. And then I'm thinking, all right, and then you just flip back. Tom Cruise he's against the odds, right? He's defending these guys and in this base, and he's put together his team. All right, I don't have teams. But then he gets to do things like fly out to Cuba. And could I see where you kept him? Let's talk about how you run your base. Could I get those flight logs? And then I'm like, well, surely maybe we could get there someday. But I think if you go into state courts, nobody's flying to Cuba. Very rarely are you going to see public defenders who get to make it out to the crime scene or to the neighborhood where anything happens. Most of the time, just as Steve said, they're going to meet their client in the courthouse, and that will be the only place they see their client. And that will be for the initial arraignment or first appearance, and then for every subsequent hearing is when they're going to see their client. That'll be the only connection to the case. They're not flying out. They're not even going to his mama's house to figure out what kind of life he led, or canvassing to try and figure out what happened in this case. Who saw anything? Was there anything to see? So then I'm like, all right, flying back from Cuba, talked to Jack. He was none too happy to see me. And the team gets to work, and there's these meetings, and there's flip charts, and they get to think about things, and there's all this, well, let's write this, let's file that, or have you done those examinations? And then I'm like, all right, in state court, what happens is you're not getting all that discovery. Even in the example, the lawyers who represent folks down in Guantanamo can't take in their notes. They can't have paper to write on when they meet with their clients. Government won't allow it. And certainly we, in our work, government simply won't allow it. We don't get a lot of paperwork. You get a police report, and then you'll find out if a statement was made, they'll say a statement was made. You don't get the substance. That's discovery in state court. And then when you come to the case, it's from the hip. That's all you got. You don't know what witnesses are going to say because they don't have to talk to you, and there's no tools for you to make them talk. And then you hope for the best. That's not resources. That's not parity, and that's not justice. But that is what happens every day in state court. We endeavor to do better in New Orleans. We try very hard to make sure our lawyers are well prepared, well trained, and ready for the fight. But all this hubbub about what's going on, for example, in federal court, not to pick on my federal colleagues, but judges like, oh, this is a travesty. That has been going on. Sorry, Judge. That has been going on in state courts since and before Gideon. And Louisiana is a big source of a lot of rights. Duncan, we gave you the right to trial. Duncan versus Louisiana. Gave you some of the greatest discovery cases, because we don't give any, right? And so the fight really is, and when you get down to state courts, the reality on the ground is this is a crisis. It does take more, and what's being done isn't enough. And maybe DOJ is perhaps not enough, can't do enough. But the reason why they're able to do something in juvenile cases is because there's a law that says they can enforce it. There is no law that allows them to enforce it on the adult side. So you can be as bad as you want to be as a state, as long as you're sending adult black men and women and poor people to jail in droves. And that to me is really scary and something that gets on my nerves a lot, despite how much I love a few good men.
Thank you. I should say two things. If you want a question, write it on a 3x5 card and give it to somebody. And secondly, 95% of these folk who are in the federal prisons came from the state courts. It's all that we'll talk about federal courts, but they come from the state courts. Carla Hernandez is the public defender, longtime public defender in El Paso. I'm not going to spend time with introductions. It's in the material. But one of the things that many of you who don't deal in this area may not know is the extent to which mentally ill people are now dumped into the criminal court system. It's usually the largest mental institution in any community is the local jail. Could you talk about?
Sure. Good afternoon, everybody. It's a pleasure to be here. In Texas, the right to counsel for everybody charged with a crime was recognized about a century before Gideon was decided. The problem is that having recognized that right, nothing was really done about it. Texas has always left that mandate up to the counties. And so what we've ended up with is a system where we have 254 counties basically doing their own thing. Our office was created as a result of a civil rights action brought by inmates because they were in the 1980s, indigent defense in El Paso, as in most of Texas, was provided through private appointed assigned counsel. There was no public defender's office. In 1975, I think, the very first public defender's office was created. That was in Austin, and that was only for juveniles. In the 80s, around the same time that the El Paso office was created, were two other offices, one in Webb County, which is Laredo, and one in Dallas. And that's about it. What was happening is under the Texas code, a person was entitled to be indicted within 90 days from the time of arrest. And if they weren't indicted within that time, they had the right to be released on bond or PR bond, on whatever they could make it. But the idea was that they be released until and if charges were brought by the DA. The problem is that the judges were not appointing a lawyer until the time they were indicted and set for arraignment. So the DA, at that time, the DA was typically waiting maybe about 100 days or so was the average before somebody was indicted. But there was nobody to check and see who should be there and who shouldn't be there in jail. Paperwork was taking a long time. So you'd have these inmates languishing in jail, some of whose cases had already been declined, and they were still locked up in jail at great human cost, not to mention the financial cost, which was what the county really cared about. It just so happened that at the time, El Paso was also experiencing some problems with the jail standards. And so there was this professor from UTEP, Professor Graves, who was appointed to look at the jail population problem. Little did they know that he was also associated with the ACLU. And so a movement was born because he saw the statistics, he saw what was going on, and he was able to get some local lawyers to bring suit on behalf of these inmates. And so in settlement of this lawsuit, My office was created, as was the office of the jail magistrate, so that for the first time, there would be a judge to look at people who were in jail, see how long they were locked up, make sure that they were given a lawyer. And so as a result of that, in El Paso, we've done a lot better than we have in the rest of Texas. But we find ourselves, with respect to the mentally ill clients, which we have a tremendous population. In El Paso, the jail is the greatest mental health provider. About 40% of the inmates receive treatment for some kind of mental disease or condition. And so what we find ourselves is in the intersection of a system that rations justice and a system that rations mental health, because Texas is one of the worst states as far as providing resources for mental health services. And so what we end up with, individuals who are arrested because they don't get the medication, the counseling, and other treatment that they need for their mental health problems. And so the criminal justice system is having to deal with them. And yet neither the jail nor the criminal justice system has the resources or the skills to deal with this population. And so when our lawyers are defending these individuals, it's a big challenge, because defending someone with a mental illness takes about twice the amount of time than it does to defend someone who doesn't have a mental illness. It takes twice the amount of resources. We need social workers. We need to resort to local resources. We look for mental health professionals that don't exist because the resources simply are not there. And so we find ourselves, for example, when our lawyers are trying hard, working hard for their clients, they get a judge who understands what's going on. They put the client on a PR bond. The client gets released, and they find about 40% of these clients find themselves coming back to jail on a new offense, or because they failed to report to the PR bondsman or violated the terms of their release. And that's because they don't have, once they get out, there's no net to take care of them and ensure that they keep going to court. And that really is our greatest challenge, is this population.
Thank you. One of the other things about solving this problem is that there are, of course, exemplary public defender offices, the Bronx Defenders in New York, Public Defender Service here in the District of Columbia, the Colorado state system. But the federal defenders have really been among the model programs in terms of how people could be represented properly and with the thoroughness and sophistication required. David Porter is with us. He's a federal defender. He's a federal defender in the Eastern District of California. And as we were just talking about, as Tony West was, sequestration is now having quite an impact on what federal defenders can do.
Yes, it is. Thank you, Steve. Before I get to that, I'd like to thank Caroline and ACS for inviting me to speak here today, and Kanya Bennett for organizing the panel. It's a privilege to be here with such distinguished speakers. Before talking about reclaiming Gideon, I hope you'll indulge me for a few moments to talk about Gideon versus Wainwright, the case itself. I highly commend to you, if you haven't read it already, this little book, very short, called Gideon's Trumpet by Anthony Lewis. Now, if you speak to people at this conference of a certain age, they will tell you that this book is the reason they went to law school, or the reason they became a public defender, or the reason they do public interest work. It's a great book. Anthony Lewis eloquently summed up the feelings many of my clients have, and I'm sure, or I imagine, that Clarence Earl Gideon had when on August 4th, 1961, he stood up in Judge McCrary's court and said that he was not ready to proceed to trial because he didn't have a lawyer. Lewis wrote, "Probably no one can adequately appreciate the need for a lawyer in a criminal case until he is himself a defendant. the sense of loneliness, the confusion of guilt and outrage, the feeling that one is caught up in machinery he does not understand. All these emotions well up in a person who finds himself arrested for even a moderately serious traffic offense. Well, Clarence Gideon wasn't facing a traffic offense. He was facing 5 years for breaking and entering the Bay Harbor pool room, charged with taking change from a cigarette machine and a jukebox, taking some bottles of wine, beer, and Coca-Cola. Now, as fascinating as the book proper is, with its detailed description of how Abe Fortas brilliantly pursued his Supreme Court strategy, I find the most interesting thing about this book is the epilogue. The epilogue describes the retrial of Gideon after he won in the Supreme Court. Abe Fortas wrote a letter to the local ACLU, and the ACLU sent 2 of its lawyers out to interview Mr. Gideon and to represent him in his retrial. Well, these lawyers weren't very impressed with Mr. Gideon's ideas that his retrial was barred by the Double Jeopardy Clause and violated the statute of limitations, and you should file a motion to change venue. He insisted on all these things. They weren't impressed. Apparently, the feeling was mutual, because at the pretrial conference in Judge McCrary's chambers right before the second trial, Gideon made himself very clear. I want to plead my own case. I want to make my own plea. I do not want them to make any plea for me. The judge says, you don't want Mr. Simon and Mr. Block to represent you? No, said Gideon. I don't want them to represent me. I do not want them. That's in all capital letters. That's in the transcript itself. Here is a man whose name stands iconically for the right of appointed counsel, stating in no uncertain terms he doesn't want appointed counsel, he wants to represent himself. Poor Judge McCrary. He's thinking, well, that is the last thing in the world I want. Sheepishly, he asked Mr. Gideon if there's a local lawyer he'd like to represent him. And Gideon said, thankfully, there was. W. Fred Turner. For the record, Judge McCrary said quickly, I am going to appoint Mr. Fred Turner to represent this defendant, Clarence Earl Gideon. He said it quickly. Turner did a magnificent job. And after the jury deliberated 1 hour and 5 minutes, it announced its verdict, not guilty. Now, I've been asked here today to talk to you a bit about the challenges to the federal defender system of sequestration. What a terrible word that is. It's even worse than it sounds, let me tell you. The problem, as you know, in March, Congress didn't do its job, didn't pass the federal budget. So who suffers? The nation and the poorest among us. Instead, they imposed a 10% mandatory, across-the-board, indiscriminate cut for virtually all federal programs and agencies, including the Federal Defender Program. Now, Tony West talked a bit about some of the responses. All federal defender offices are autonomous, and so the responses have been different. So he talked about New York and Boston. A federal defender in Ohio rather famously fired himself, effective June 1st, rather than firing his recently hired staff who hadn't passed the Ohio bar. One office is going to close during the month of August. The Northern District of California, the courts there close on alternate days, and therefore the Federal Public Defender Office closes on those same days. And in Sacramento, we have 2 furlough days a month. Now, let me paint just for you very briefly an overall view of the situation and explain why I believe that this is penny wise, maybe penny wise, but certainly pound foolish. First, 90% of defendants in federal court qualify for appointed counsel. And they are entitled to counsel under Johnson versus Zerbst, a 1938 decision predecessor to Gideon versus Wainwright. So if the federal defender office is not available because of cuts or otherwise, those defendants still get appointed counsel. They are appointed private panel attorneys. Now, in the Eastern District of California, in a letter that today is going from the federal defender to the chief judge of the district, she is explaining to him that the costs of representation by our office are on average 11% less than the panel. That works out to $1,200 to $1,500 per representation. At 186 representations per year, that's $225,000 to $280,000 a year, and we're only one of 88 federal defender offices nationwide. But that is only the beginning, because these costs cause continuations, because defenders aren't available. They cause greater cost for pretrial custody, which at $2,400 per defendant per month rack up. But here are the real costs. The federal defenders were started in 1970. We have the expertise, we have the experience to represent people in many ways that the panel does not. So there will be 4 effects for these cuts: significant delays, less reliable outcomes, longer sentences, and costlier appeals and habeas proceedings. These are going to be tremendous costs down the road. And finally, I want to just point out the disparity in prosecutorial and defense costs, or resources. The Department of Justice, so far as I know, has not furloughed a single employee. In fact, in Tampa, Florida, the U.S. Attorney's Office has 4 new staff, while the Federal Defender Office has laid off 12 of its staff. The Federal Defender's proposed budget this year, $1.078 billion, is 0.05% of federal spending overall, and 4% of the DOJ projected budget this year of $27.6 billion. So what I want to conclude with these introductory remarks is that the real danger here is that this is going to become the new norm, the new benchmark from which future budgets are going to be judged. In fact, in 2004, fiscal year 2004, the Administrative Office of the Courts has warned that there are possible 14% additional cuts in addition to the 10% sequestration, which, if continued into fiscal year 2015, would result in a layoff of 1/3 of the federal defender staff nationwide. So, as the retrial of Gideon proved, I think, lawyers do make a difference. And this sequestration and the future cuts, make no doubt about it, threaten that system. And so Steve promised to get back to us with the good news that we're going to tell you about, and we'll hold you to that.
And we'll do that by turning to Chief Judge Lippman. We'll go back to the state courts and look at the leadership that's being provided there to do something. I know you've got some problems in some parts of New York. You've got some exemplary offices in other parts.
Let me just say, Steve, that I agree with everybody about the state of indigent defense. This isn't a secret.
Right.
And I think we're all in agreement, and everyone has been to the Gideon celebrations. They're a little bit muted because of the present state of indigent defense. But I think this view was expressed by you and by Tony West, that I don't see the purpose of just bemoaning our fate. And
right.
And there is a lot to be unhappy with 50 years after Gideon. But at least from my own perspective, we should be doing something about it. And that's what we've tried to do in New York as an overview of what we try and do, or the structure within which we try to do it. We've established an indigent defense board in New York, which is a tripartite body that oversees indigent defense in the state. That is, its mandate is to provide a vision of the future of indigent defense in our state, which is a county-based system. And lo and behold, the head of that board is the chief judge. And, and the question was, gee, what the hell is the chief judge doing as the head of the Indigent Defense Board or setting out this vision? And the answer is that's what we're supposed to be doing. I mean, all of us in the criminal justice system, our role is to pursue justice. The judiciary's constitutional mission is to foster equal justice. So I don't think it's so strange. And of course, it helped that the chief judge was a part of negotiating that bill, and maybe that's why the chief judge became the chair. But we have a board, all three branches, indigent defense represented on the board very strongly, and we give out monies from the state budget to enhance indigent defense in our state. And, and I think Steve is right. I mean, the amount of money that you're talking about that the federal government is devoting to this function is, to say the least, sad. I mean, it's just so inadequate. I mean, we've given out, in this last period, we just announced $12 million in grants for representation at first appearance. What could be more basic? And yet in parts of our state, particularly the more rural areas, there is no representation at arraignment. Mind-boggling. But we are doing that. We're also just giving out $8 million, or about to, for complying with Padilla. And we think that's such a basic responsibility that we have. We're giving out another $12 million to deal with upstate caseloads in the indigent defense entities around the state. In New York, in New York City, we passed legislation with case caps as to what caseloads that the different defenders are allowed to have. And all these things, I think, are obviously enhance indigent defense. And then there are so many other related issues that we should be taking the lead on, whether it's bail, where we have a system where people stay in jail because they can't make $500 or $1,000 in bail payment because the bail bondsman wants to make a profit and they don't want to bother with $500 or $1,000 in bail. And you have people who are no threat to society, will not flee the jurisdiction, and yet we keep them in jail, away from their families, away from the job, and put them in such an unenviable position in terms of plea bargains. And wrongful convictions, whether it be videotaping of interrogations, access to DNA base, double-blind lineups, are all things that also supplement this effort to enhance the indigent defense function. Reforming juvenile justice, all of it are policy-based things to enrich our indigent defense system, and we certainly have our problems, and promote criminal justice reform, understanding that there are also basic things that should be done in our state. We have a lawsuit that attacks systemically the indigent defense system in the state. I wrote a decision, the majority decision, that allowed that lawsuit to continue. But in the end, in the long run, the policy side is where we're going to make progress. And I believe that this requires leadership by every part of the criminal justice system, and particularly the judiciary, given our constitutional mission. And I don't think it's an issue of activist judges. I think it's an issue of the judiciary being proactive in the pursuit of justice. This is what we should be doing.
And to talk about how the prosecution can be proactive, I want to call upon my good friend Scott Burns, who's the executive director of the National District Attorneys Association. One of the sort of riddles of indigent defense is, how do you get the government that's trying to convict people and imprison them or execute them to at the same time provide lawyers for them to defeat that very purpose? And I think most governments have not been willing to do that. What's the role of the district attorneys across this country in dealing with these problems? You would agree we got the problems, right?
Yeah, since I've sat here this morning, it's been very interesting. I don't think a lot of Americans really appreciate the fabric of the American criminal justice system. We talk a lot about federal defenders and United States attorneys and federal judges, and they are extremely important. You initially said NAG, the National Association of Attorneys General. Attorneys Generals in this state prosecute less than 1% of the cases. 95%, and I can't tell you how many calls I get a day about this federal case or this federal law, or the Attorneys General said this about this federal program. And I try not to yawn, but I say 95% of the 10 million felony level cases are handled by state and local prosecutors. That's one. Another thing people don't understand, 85% of those offices have 4 lawyers or less. Think about that. The Houston and the Miami and the New York and the New Orleans and Harris County are the gross exception. 85% are really small offices. A 1-woman office in South Dakota, a 2-person office in Nebraska. And the public defender or the indigent defender system is often set up, mirrored, and monitored in those counties. So sometimes I think that we would all agree, I think that Louisiana is sui generis. I mean, the problems that have taken place there, you got to admit it, right?
We're pretty special.
And Georgia has had problems. I just spent 3 days in Boston training district attorneys. They will tell you a large portion of the state legislature there are former attorneys, former public defenders, and the public defender system in Massachusetts is far better funded and supported than the prosecutors. John Blodgett in Essex County had to do furloughs. Everybody's got hiring freezes, and that's from him to Keith Kaneshiro in Hawaii and all across the country. So when we sit here and I won't say whine, but complain about no resources, it's not like we have enough money to do indigent prosecutions. We take our victims as they come. Has anybody out here ever been a state and local prosecutor? Anybody? I got somebody. Did you ever go out on the street and say, you know what, I'm looking for a defendant? Did you? They brought you the case. And did you ever say, you know, we prosecuted too many African Americans this week. Could you bring me some white people? Did you? Did you ever look at a file when you screened the case? Were you able to tell did they have a booking photo? Did you know who you were prosecuting? Or was it a person alleged to have hit an 83-year-old woman in the head with a pipe, and you don't give a damn what color he or she is? We take our victims and we take our defendants as they come. I'll give you another thing it's just another example of prosecutors across the country. I was in an ABA function and somebody was talking about the crack cocaine powder disparity. My God. You know, it was an attempt to take young African American males and lock them up forever. And finally, we've got an administration that's going to look at that and right the wheels of justice. But people forget, Ronald Reagan proposed 50-1. You know who passed the crack powder cocaine disparity law? It was led by a guy named Charles Rangel. You know who demanded that it be passed? It was the Black Caucus of the United States that said we are sick and tired of our wives and our mothers and our children being unable to walk to school without stepping on needles or condoms or being afraid of being assaulted. We want to take our cities back. And you know what happened? These people pass laws. And they're the ones that elect the prosecutors, those of us that do 95% of the prosecution. They elect us, and you know what they said? We're sick of it. We are sick of crime. Crime is down 30 to 40% in the last 30 years for burglaries, rapes, and robberies. In the city of New York, in 1990, there were 2,200 murders. This last year, under 400. Crime is down in the United States. There have been great successes, and yes, we need to better fund indigent defense, and yes, we need to support the courts and look for leadership from our judges and our prosecutors, but it does no good. It does no good for us to point the finger at each other and fight over scarce resources. I think and we've tried to do that. Stephen, you and I have met, and Virginia Sloan and Kate Clark and Barry Scheck and a bunch of us, and I think we're getting better at it, but I think it's important for all of those that are so worried about the indigent defense, and we are as well, that we are in the victim business. We are in the victim business. Our job is to take people whose lives have been shattered, people who have been raped and robbed and sometimes literally thrown in the trash. Our job is to pick them up and try and enforce the rule of law and do some justice for them in each individual case. Not to notch a belt, not to count how many cases we've won, but to do justice. And you know what? In the sequel, honestly, I'm still upset that Private First Class William Santiago's case was not resolved. And I hope Kevin Bacon does prosecute Colonel Jessup. But it's not that sexy, right? It's not that sexy. Thank you.
But Scott, I just want to say this now. Well, people clap for Scott here. I didn't mean to interrupt that. But when we had Elizabeth Warren speak last night,
Yes.
and the Senator Morgan, I said, thank goodness for Massachusetts and Oregon, because I'll tell you, Georgia's not sending anybody like that to the United States Senate, I'll tell you that. And Georgia's not providing public defenders like that, nor is Florida, nor is, well, Alabama doesn't even have a system. Texas doesn't even have a system.
Right.
I mean, in Florida, there's been constant cutback in the funding to public defenders while increasing. And I just want to add one other thing about
But
this.
you have to understand, Catherine Fernandez Rundell, the DA in Miami's budget was cut 30%. She withdrew from our organization because she said, I can't pay the $1,100 to have my office a member of your organization. I'm sorry, I'm on your board, but our budget has been cut 30%. So I
and
think
the public defender, even years before that, was cut even more.
well, that's what I'm saying.
I mean,
but we can
that's
sit
why
and-
this case that just went to the Florida Supreme Court about the public defenders. And let me just ask you
Okay,
your
let me
opinion
answer-
on,
let me
ask
respond
you
to
your
that.
opinion on this case. Well, let me just ask this one
Yeah.
case. Bowen versus State, which went to the Florida Supreme Court.
Yes.
A public defender in Miami
Yes.
says to a judge, I can't take any more cases. I've got this huge caseload.
Right.
And ethically, if I take another case, I will either be not competent
Right.
for this lawyer or the lawyers or the clients I already have. Judge said, absolutely. You've got an ethical responsibility. The prosecution appealed that. Now, I want to know, what interest does the prosecution have in appealing? And believe it or not, got it reversed so that the public defender who says, ethically, I can't take another case, has another case dumped on him. And the only thing I can see there is that now the public defender is so overwhelmed, he can't represent his client. Now, that got reversed by the Florida Supreme Court. But what's the prosecutor's interest in overburdening a public defender so that he can't competently represent his clients?
You're not a very impartial moderator.
That's why I'm here. I'm going to step in.
I just wanted to.
You suck.
I asked the hard questions. That's what you're supposed to do.
He wants to win his case.
Yes.
When all else
The
fails,
answer
go
to that
ad
is what we've been calling for 4 years, and that's the National Institute of Justice to do a comprehensive study nationwide. Because what happens is we count different. If I charge you with a 10-count indictment of forgery, you plead guilty to 1 count, I count it as 1 case in some places in America. The defense office counts it as 10, 9 acquittals and 1 conviction. We don't have apples and apples nationwide in assessing caseloads. Some people in Miami that I reached out and talked to and said, you know what, they're making this up. They're not that busy. I got prosecutors that have more cases and I can prove it. And oh, by the way, we have another job. And my one prosecutor friend out there will tell you. In the morning you get a stack of files and you want to talk about exonerating people. You still have to read all of those. You still have to sit down with the detective. And when you don't charge those 5, which takes a lot of time, it still counts. And it doesn't count in a caseload assessment. So I liked it when you or somebody before said, we need to do a comprehensive study to see, are they really overburdened? And are the prosecutors overburdened as well?
I didn't say that because I think it's as obvious as the nose on one's face. But let me ask, we're almost out of time. Let me ask Judge Lemon, one of the cards we had here was about what can the private bar do with regard, or are you seeing that as part of the solution to your problems in New York?
I think it's all of us together. I don't think you could say that the private bar has no role. We think everyone has risen to the occasion. You know, we have a whole debate in New York as to how large the private bar should be. Private bar's role should be in indigent defense. You know, I think this is and I say this not to be corny, I think it's a team effort. I think that all of while we all come at it from a different perspective, we all have the same goal. And that's pursuing justice. And I think that whether it's the private bar, whether it's the public defender, whether it's the prosecutor, whether it's the judge, it's the same. So I don't think there's any one part of the system is going to solve this problem. I think it's all of us working together, and I think that's very basic. And I think, though, in particular, government has not really, it's very uneven, but has not recognized its responsibility. And I think that's something that we've tried to change in New York. And I think at the state level, because at the federal level, there's so talking about the sequester and all the things going on. At least in the states, there is some variation on the resources that are available, and you can get local government's attention. I think in some ways a lot easier and a lot sooner than you could do it at the federal level.
I mean, one thing I want to say about the bar is different roles. One is providing, like in conflict cases, representation.
Yes.
If local law firms in different jurisdictions, like those that were part of the Hurl Haring suit, would provide, because, but also the bar associations in the state taking ownership of this. I mean, lawyers have a monopoly on legal services. Doesn't some responsibility come with that?
No, but you're right. I mean, we've had, as the head of the State Bar Association in the last year, the head of the Criminal Defense Office of the Legal Aid Society in New York City. So the bar in many states is on top. His top priority, Seymour James, as some of you may know, is, enhancing indigent defense in the state. But I think that it's very uneven around the country, and we've got to get everyone's attention. And obviously the Gideon celebration, in quotes, is the perfect opportunity to do that, to say, gee, look what's happened in 50 years since Gideon.
One other question I have here is we've gone, of course, in 1970 we had about 200,000 people in prisons and jails, now at 2.3 million. So we've gone to mass incarceration during this time. And as someone points out, one of the problems with resources scaling back the scope of the criminal justice system. Is there a way to downsize the system to take some of the pressure off of it? Derwyn, you want to?
Well, sure, and I think the answer is yes. And I think one of the things we've been doing at my office for the last 4 years is arguing for reforms in the system. Because part of it is you have to treat the system as a system. And not to take issue, but I think to augment with the perspective of the district attorney's office, we're all in the victim business. There's no such thing as a one-sided case. And what we've been able to do is talk about the collateral consequences that come from a system that's too big, too punitive, too stupid. And so what we've been able to do in the 4.5 years since I've been chief is argue for more robust pretrial services, more early intervention in cases, more alternatives, and from our perspective, a more holistic approach to representation. And when I got to the office, there was an average daily population in our jail of 3,600 people. That is now down to below 2,000 on the average daily population. Our arrests we arrested between 75 and 80,000 people a year when I got there. Last year it was 34,000 because we wanted to focus more on serious crimes, get rid of the out-of-state warrants, and don't worry about the small things, and they're all small things from a defender's perspective.
Really small.
And what we've been able to do is we've been able to shrink the size of our system to the point where even though we've been taking cuts, and I've cut my office nearly $3 million in the last 3 years, and I predicted doom and gloom, but because we are sort of feeling a little bit of a reform dividend, we haven't gone through the roof. We're still over standard, but it is not what I thought it would be because folks paid attention to the system, shrunk it. Our murder rate is down, our city's safer, we're the fastest growing city in America, we've got one of the best economic engines in America. The sky does not fall if you do not send poor people, people of color, to jail in droves. It doesn't.
We have many other provocative questions on the questions that came in about mental health courts and other things, but unfortunately, we're out of time. So I just want to say for the people, I want to thank everybody on this panel for the contributions that they made. Thank you very much. I wish they had more time, but I hope that everybody will take back to wherever they're from that something's got to be done about this, at your law school, at your law firm, and your whatever it is you do, because lawyers own this system of justice, and we cannot maintain this monopoly and let this sort of thing go on in the courts, I just think. The panels I've been asked to describe. The Fresh Perspectives on the Future of Federalism is in Federal B room. I guess that's appropriate. The Federal Perspectives in the Federal B room. Money, Politics, and the State's Courts, the Threat to an Impartial Jury, which is a serious problem, in Federal A room. Federal A room. Worker Voice and the New Era of Organizing will be in the Senate room. And the final panel, which is on a class act, the Supreme Court and class action cases, will be in the congressional room. Thank you all for your time, your attention, and have a great afternoon.